For everybody here, we appreciate you joining us. My name is Daniel O'Neill. I'm the chair of the HYLA CLE committee this bar year. We're really fortunate to have a fantastic speaker here with us today for this presentation. For those of you who don't know, he's also going to be joining us May of 22 for the last CLE of the bar year. So let me go ahead and introduce him. Daniel Olds is an associate with Bickerstaff, Heath, Delgado, Acosta, LLP in Austin, Texas. He focuses his practice on trial and appellate litigation. Prior to joining the firm, he served as an assistant attorney general in the tort litigation division with the Office of the Attorney General. He also served as a lead appellate attorney for expunctions at the Texas Department of Public Safety and as a briefing attorney for Chief Justice Jim Wright of the 11th Court of Appeals in Eastland. He received his JD from the University of Georgia School of Law and his BA from the University of Texas at Austin. So if you all stay tuned towards the end of the presentation, I will give you the MCLE number. And if you have any questions throughout or any kind of sidebar you'd like to bring into the conversation, just put that in the Q&A box down at the bottom of Zoom and we'll get to it in turn. So at this point, Daniel, please take it away and thanks for joining us.
All right, Daniel, appreciate it. Thank you all for being here. So obviously this is a presentation about statutory interpretation. I'm going to try to focus the presentation a little bit more on Texas, but what we talk about is going to have a lot of applicability to how things work in federal court, how things work in other states, but just keep that in mind. So normally when I tell people I'm doing this presentation or when I talk about statutory interpretation, when I talk to my lawyer friends, I expect them to I expect their faces to light up and just get really excited about this topic and expect them to really engage in it. But oftentimes when I tell people I'm doing this, they look at me like I'm telling them I'm giving a presentation on paint drying. And it struck me at some point that people don't really appreciate just how interesting this topic is. But it is really interesting because statutory interpretation is all about how the legislature, how courts, and how the executive branch all talk to each other in this state, and how that impacts your legal practice. So one's very theoretical and also very, very practical. And the reason it's practical is because there is a statute for just about everything nowadays when you're practicing law, no matter the situation, no matter what area of law you're practicing in. There's been a proliferation of statutes the last few decades in Texas. At the federal level, this goes back to kind of the start of the New Deal. The federal government started passing a lot more laws, a lot more statutes. In Texas, this trend has been going on for about 20, 30 years. The legislature, passes lots of laws. They've codified a lot of common law rules that we used to have. And so now statutory interpretation is really important for all lawyers in the state, no matter what area you practice in. And just to prove it to you, I'm not the first one to say this. So this is a quote from former Texas Supreme Court Justice Don Willett. The lion's share of modern day appellate judging is legisprudence, right? Interpreting statutes. Day by day, the universe of freeform common law judging shrinks, meaning the bulk of this court's time is spent deciding what the legislature's words mean. I actually went to a panel of the Texas Supreme Court a few years ago, and someone asked Chief Justice Hecht, who's been on the court since I think 1988 or 89, what's the biggest change that he has seen since when he first got on the court to now? And I think they were expecting him to talk about technology or the internet, things like that. But he didn't hesitate. He immediately said, we used to mostly decide common law cases. We were interpreting common law. We were making the common law. And now it's all statutory interpretation. That is the bulk of what we do. And obviously, he said that. Justice Willett said it. And it's really true. There is a statute for just about every area of law now. And no matter what kind of case you're litigating, there's going to be a statute that you need to interpret or make arguments from. And if you're in-house, you're constantly reading statutes or interpreting statutes. You're trying to figure out how to comply with statutes. So it's a very important area. It's, again, very theoretical and really interesting, I think, but also very, very practical from a day-to-day lawyering perspective. So I want to start us off with a little sort of example about some of the problems that we normally encounter in statutory interpretation. So pretend that we were all in the same room together, and there's a sign posted on the outside of the room that says food is prohibited in this room. So that leads to a number of interesting problems that we may face. So can you eat a sandwich? Well, probably not, right? A sandwich is pretty obviously food. that's not allowed in the room. So no, you probably can't eat a sandwich. Can you drink water? Water's not really food, right? You don't eat water, you drink water. It's got no nutritional value. So maybe water's okay. But at the same time, water can create a mess. It can be distracting, but probably not really. So maybe water's okay. Can you drink orange juice? Orange juice is kind of like water, but then it's got nutritional value, right? And if you spill orange juice, it can be sticky, it can be messy, it can attract bugs. So maybe there's a difference between water and orange juice. It kind of goes, so, what is food, right? What's the plain meaning of food? Do we care about why that sign was posted? Was it to create a mess? Was it to keep bugs out? Those are things we might want to think about. Can you drink a yogurt smoothie, right? I mean, there's more viscosity with the yogurt smoothie than there is with orange juice or water, right? But you're still drinking it. So you're not eating the yogurt smoothie necessarily, but there is more nutritional value there. That's also going to create a mess though if you spill it. That could be distracting if you're slurping a yogurt smoothie, right? So maybe there's a different conclusion for a yogurt smoothie. You might also ask, can you chew gum, right? That's not really food. Most of us wouldn't think of gum as food. There's maybe negligible nutritional value from gum, and maybe like 5 calories. But again, if you put the gum, if you drop it on the floor, that's going to create a lot of mess, right? It's going to be really distracting if you're chewing gum. Like I'm not going to be able to concentrate really well if you're over smacking on gum. So maybe that's the purpose behind why this sign is on the front of the room, to so I'm not distracted, or maybe it's to prevent mess, or maybe it's to do something else that we're not thinking about. Can you chew tobacco and spit it into a small bucket you carry with you at all times? Again, tobacco is not food. You're chewing it, you're not eating it. But this is very distracting. This would create a lot of mess. It's just kind of gross, right? If you're doing this in the middle of a presentation. So all things to think about. And finally, can you keep a peanut butter and jelly sandwich in your bag and eat it in the hallway in between presentations? So, this violates the clear, letter of the rule, which is food is prohibited in this room, right? You're bringing the sandwich into the room. You are technically breaking the rule, right? At the same time, you're not eating the sandwich in the room. And, does that matter, right? Do we care about mess? Is anyone even going to see it practically? All things to think about. And then does it change if you have a medical condition that requires you to eat at periodic intervals throughout the day, including this presentation, right? So does that somehow override what the plain text of the statute says? These are all things to think about. There are no really easy answers to this, but as you hopefully start to see, a lot of this depends on kind of your theories of interpretation, how you go about interpreting statutes, and trying to figure out what this statute means and why whoever posted the sign posted it there. So how do Texas courts interpret statutes? You might be thinking to yourself, I know who's on the Texas Supreme Court. I know how things work in the state. They adhere to textualism, right? And they really like this book written by this guy and Brian Garner. That's what we need to know. I gave this presentation a few years ago, and I did this whole thing at the end of the hour. I took questions, and someone raised their hand and said, they didn't have a question, but they said, all you really need to know about statutory interpretation in Texas is that they follow the Brian Garner Scalia book, right? You don't need to know anything else. Just read that and you're fine. Like, this presentation is stupid, which hurt me a little bit because, I put in a lot of work on this presentation, but also is maybe glossing over some interesting issues that arise in statutory interpretation in the state, because, you may have noticed that not all Texas Supreme Court cases are unanimous. All these statutory interpretation cases that they're working through produce different results and a lot of fractured opinions. So something else is going on here, right? Yes, they all adhere to textualism, right? But that doesn't mean that they're all going to come to the same conclusion. And so part of what's happening, and what I want you all to take away from this presentation, is that they adhere to textualism, but they still disagree about its application, right? Why do they disagree about its application? Well, there are different ways to determine plain meaning. The context in which those ambiguous words and phrases are found in statutes is important. what context they look at is important, how they interpret the context is important. And also there are a lot of legal fictions that go into statutory interpretation. And those legal fictions are really important in understanding how judges go about interpreting these statutes. So I want you all to just kind of think about this. We're going to talk through a lot of these issues. I'm going to go through kind of the basics of statutory interpretation, some of the main rules that come up. I'm also going to go through some of the kind of big issues that are going on right now in statutory interpretation, especially in Texas, and then just kind of some things to think about. So yes, Texas courts adhere to textualism. What is textualism? It is the idea that a statute's authority comes from its enactment as law, and thus a statute's meaning does not change over time, right? So the legislature that enacted a statute, their intent is what we care about, right? We don't care about the intent of future legislatures who did not touch that statute. And how do we determine what that intent was? We look solely to the text of the statute, right? Solely at statutory text. We don't look at legislative history. We don't look at things like that. We just look at the text of the statute. You can contrast this with intentionalism, which is similar in that we care about the enacting legislature's intent when it passed the statute, right? When it enacted it. But we might look at legislative history. We might look at floor statements, at committee reports to try to get a better sense of what the legislature was thinking about when they passed that statute. Purposivism is another theory of interpretation that some folks use, and that has more to do with, what was the main purpose behind the statute, and how has that statute sort of evolved over time? What role does it play now? It's a little more amorphous. It's a little harder to pin down exactly what purposivism is, and that's a really broad generalization that I just gave you. But basically, it's not just looking at the enacting legislature's intent behind the statute. It's how has the statute evolved? What does the statute mean today? And you can look at a number of different things: text, legislative history, court decisions, things like that, to determine what the statute's purpose is today. So when you're engaging in a textual analysis of a statute, if you're in court making an argument about what a statute means, say you've got an ambiguous word or an ambiguous phrase in a statute that you're arguing about, how do you go about making those arguments? And I think the best way to do this is think about it like a microscope, right? You're going to zoom in on that ambiguous word or that ambiguous phrase, and you're going to make arguments about what that word means, right? What the ordinary meaning of that word is. Maybe look at dictionary definitions, and then you're going to zoom out slowly, right? You're going to look at maybe the sentence that word is found in. How does that sentence tell us what that word means? Zoom out a little bit more. What section of the statute is that in? Zoom out even more. Maybe look at the entire statute. Then zoom out even further and look at other statutes to see if that sheds light on what that ambiguous word means, right? So again, zoom in all the way to that word, that ambiguous word, with the surrounding words, then the larger statutory scheme, then other legal texts. So when you're trying to figure out what an ambiguous word in a statute means, remember that statutory definitions always trump any other definition, right? So if the statute defines a word, it's not ambiguous in that sense, right? Now the definition may be ambiguous, and you may be arguing about what something in the definition means, but the word that the statute is defining has a defined meaning in the statute. So that controls overall other definitions. Also, if the word has an established legal or technical meaning, that definition also normally prevails. So if it's a scientific term, or maybe it's like a banking industry term, and there's sort of a general understanding of what that word means in that arena, you apply that definition. Oftentimes, neither one of those things are going to be helpful. So you've got to figure out what an ambiguous word means on your own. And then courts will try to determine a word's plain meaning, its common meaning, or its ordinary meaning. Those words are used really interchangeably by courts. And it's interesting because they treat those three words as kind of meaning the same thing, but they're also sort of different. Plain meaning is pretty self-explanatory. Common is that the word that people commonly use? That doesn't mean it's necessarily the right word, the right definition of a word. Maybe the dictionary, written by folks with PhDs, has a different meaning than what how a word is normally used. Interesting things to think about, but normally those all sort of mean the same thing. And a lot of these rules are judge-made, but there is a statute in Texas that actually tells us how we're supposed to interpret statutes. It's called the Code Construction Act. You find that in the Government Code, Section 311. And textualism is really codified in the Code Construction Act. So here you see Government Code, Section 311.11. Words and phrases shall be read in context and construed according to rules of grammar and usage. Words and phrases that have acquired a technical or particular meaning, whether by legislative definition or otherwise, shall be construed accordingly. Right, so you see a lot of, especially intermediate appellate courts citing the Code Construction Act when they're doing statutory interpretation. You don't see it quite as much at the Texas Supreme Court, but it's always a good thing to throw into a brief, into a memo, whatever you're writing as an extra persuasive authority. So again, how do we determine what a ambiguous word's ordinary meaning is, what its common meaning or its plain meaning is? Oftentimes, what courts most often do is look at dictionary definitions, right? So if you've got an ambiguous word, you might pull up Merriam-Webster's, you might pull up Black's Law Dictionary, especially since we're lawyers. There's a question about what dictionaries we should use. This idea has been floating around for a while. In Texas, there's not really a definitive answer to that. You'll see Black's Law Dictionary cited a lot. You'll see Merriam-Webster's. You'll see all sorts of dictionaries get cited. And so, you know, if you're using one or more of those dictionary definitions, you're probably on solid ground. An issue comes up though about, you know, our dictionary is kind of acontextual, right? It's really easy to just pull a favorable definition of a word from a dictionary that supports your argument, right? And that's maybe a problem, and we'll see in a little bit that maybe some folks don't always like using dictionaries, but I'd say more often than not, judges like using dictionaries to do statutory interpretation, and it's usually a good idea to do it if you're writing a brief for a motion or trying to make an argument to a colleague about what a statute means. So what are some other sources of ordinary meaning? You might look at other statutes. Maybe another statute defines the word. So maybe you're trying to interpret an ambiguous word, say in the occupations code, but that word is also defined in the government code. You know, maybe that definition can shed some light on what that means in the occupations code. Rules of evidence or procedure, if that word is used in a certain way in the rules of evidence or the rules of civil procedure or the rules of appellate procedure, that may also shed light on what that word means in your context. If that word has been interpreted in case law, that can also be helpful. Treatises could also, you know, help determine what that word means. And, you know, like I was talking about before with dictionaries being kind of acontextual, these things can also be acontextual, right? So maybe a word in another code has a different meaning for that specific code than it does for the word you're trying to figure out, right? So, I mean, if they use a word in the government code, you know, in a certain way, that could have a totally different meaning when they use that word in the occupations code, right? The legislature is thinking about different things. Same thing with the rules of evidence and case law. Those could be a little acontextual for your circumstance, but it could also be helpful. So it's important to keep in mind as sort of a secondary way of determining plain meaning. So here's a picture from ancient Rome. You might be wondering why I have this. It's because we're going to talk about some rules of statutory interpretation that have fun Latin names. So, you know, you can sound really fancy when you say this to colleagues or to courts, and you can, you know, italicize it and people think you're really smart. So some of the words, you know, some of the rules that we think about after we look at the, what does the plain meaning of the actual word mean? You know, you want to look at the immediate context. Like I said, zoom out with your microscope, look at the immediate context in which that word is located. So there's a rule called the rule against surplusage. You've got to give effect to every word and provision in the statute. You assume that nothing is duplicative in the statute. So this is kind of a legal fiction, right? Because when we talk in ordinary conversation, if you really want to emphasize something, you might repeat it multiple times to someone, right? If I say, hey, I really want you to go pick me up a hamburger for lunch, you know, and I'm not sure you're going to remember, I might say, hey, remember, I want you to pick up a hamburger. Hey, remember to go to whatever restaurant, you know, go to Whataburger, get me the burger. I'm going to say it multiple times, maybe. And I'm not trying to tell you different things. I'm just trying to emphasize I really want a hamburger, right? We don't make that assumption in statutory interpretation. We assume that the legislature when it says something that it must mean something. So you don't, you see this argument a lot in briefs. You see courts and judges make this argument in statutory interpretation opinions. None of, they're trying to figure out what an ambiguous word is, and maybe the majority opinion adopted one interpretation of that word, in the sense saying, no, there's another word here that very clearly has that meaning. So you're violating the rule against surplusage, right? You're not giving effect to every word. You're making it duplicative. A fancy Latin phrase that you can think about is notior associus, which means an ambiguous word is understood by the words around it. So, if there's a word, an ambiguous word, and it's talking about, well, for example, if you're saying, go bring me the glasses, I could be talking about reading glasses, or I could be talking about like drinking glasses. But if I say, bring me the glasses, the dishes, and the spoons, I'm probably talking about drinking glasses, right? I'm not talking about reading glasses. Ejusdem generis is similar to notior associus, but it relates to catch-all provisions at the end of a list. So if I say, bring me the glasses, the dishes, and the spoons, and everything else, when I say everything else, I'm probably talking about things that are related to, eating or drinking something, right? I'm not talking about books or furniture or things like that, right? So that's all that ejusdem generis means. Expressio unius, the expression of one thing excludes the alternatives. You see this a lot in opinions too. So if a statute says one thing, we kind of assume that the legislature thought about this, and things that might be similar, they purposely did not include in the statute. Then of course there are sort of semantic rules like and or obviously mean different things, may and shall mean different things. Including is important. So sometimes, especially before like lists, the statute will say something including, but obviously it's not limited to just those things that the statute's enumerating. And then you can zoom out even further, look at the broader statutory context. We have the whole act rule, which means the statute is supposed to be interpreted as a coherent whole, which means that words across the statute are supposed to be used. We presume that those words are being used consistently and in the same way. There's an assumption that the statutory term has the same meaning everywhere it's used within a statute, which is similar to the whole act rule. The whole act rule is a little more comprehensive though, and all the parts of the statute are supposed to be working together in harmony. But part of that is the assumption that the statutory term has the same meaning everywhere it's used, unless it's explicitly different. And also the rule against surplusage. So, we talked about it when you're interpreting a word like in a sentence, and there's another word in the sentence that could mean the same thing. That's one version of the rule against surplusage. We can also apply that, in terms of the entire statute, right? So if they use, if there's another section of the statute that seems to mean the same thing as the argument that you're making for what an ambiguous word means or what that section means, it may not be what you think it means. I know this is kind of a lot. Does anyone have any questions so far? I don't know if anyone's written anything. Daniel's going to tell me, but if you do have questions, please feel free to let me know. I know this can be kind of confusing and I'm going a little bit fast because we only have an hour, but I'm trying to hit some of the highlights. So in the context of other statutes, there's a rule called in pari materia. When multiple statutes use identical terms or deal with related issues, courts typically presume a word has the same meaning across statutes. You might be sensing a theme here, which is that we're presuming a lot about the legislature, right? We are presuming that the legislature kind of knows like what the law is when it passes statutes, right? And that they're aware of everything that exists, which is maybe not entirely true, right? But we're making that's one of these legal fictions that we're engaging in statutory interpretation. You might also look at the statutory development. This comes up sometimes, especially in opinions. If sometimes, like the Texas Supreme Court will issue an opinion where it interprets an ambiguous word in a statute, and then the next legislative session, the legislature will change something else about the statute, but not touch the part that the Supreme Court interpreted. And then there's another case later on, and where the Supreme Court has to look at a different ambiguous word in the same statute, or maybe they're saying, well, we interpreted this ambiguous word before, and the legislature kind of ratified our interpretation. Like they agree with it because then they did something with the statute, but they didn't change our interpretation of it. They didn't make it clear that we were wrong. And that's also kind of a legal fiction in the sense that, we're presuming that the legislature is paying attention to what the Supreme Court's doing all the time and what their interpretations of certain words are in every case. In Texas, the rule is that this only applies to the Texas Supreme Court has interpreted a word, but in the past, there have been applications of this rule when intermediate appellate courts have made an interpretation of the word, and then the legislature ratified a different part of the statute. But I don't want to say it's absolute, but right now the rule is usually that this only applies to the Texas Supreme Court or the Court of Criminal Appeals as interpreted an ambiguous word. So legislative changes are presumed to have significance. We presume that when the legislature changes a part of a statute, it's aware of all these opinions that the Texas Supreme Court, the Court of Criminal Appeals has issued interpreting other ambiguous words in the statute. Similarly, if the legislature changes part of the statute that the Supreme Court interpreted, we can maybe presume that they didn't like the interpretation that the Supreme Court took. There's a conflict between statutes. You should remember that specific provisions control over more general provisions, and later enacted statutes control over earlier enacted statutes. But we also presume that there are no repeals by implication, right? So we presume that the legislature did not accidentally repeal a provision in a statute when it passed something later on. It has to do so explicitly. Finally, there's the rule against absurd results, which basically means that even though the plain language says one thing, applying it would lead to absurd results. So, you're telling the court, don't apply the plain language of the statute. You see this a lot, especially when people, it's sort of like the last ditch argument that people make in statutory interpretation cases. It's not usually successful, especially in Texas, because you're basically telling the court, I know what the plain language of the statute is, but you shouldn't apply it because it's going to lead to an outcome that I don't like. And you're kind of telling the court oftentimes, I don't like the policy outcome of this. And the court's going to say, well, it's not our job to make policy. We just apply the words as written, right? Now, what's interesting is that there are different ways to apply the rule against absurd results. If you have two competing interpretations of an ambiguous word, and based on the textual analysis, they both carry kind of equal weight, then the rule against absurd results could be a tiebreaker. You could take the interpretation that just wouldn't even raise an absurd result, even if the interpretations are maybe not equal. There are different ways to apply the rule against absurd results, and we'll see this with a lot of the canons of interpretation that we're going to talk about, but how you apply it can have significance as well. Here's a quote from the court, the Texas Supreme Court: the bar for reworking the words our legislature has passed into law is high. It is reserved for truly exceptional cases, and mere oddity does not equal absurdity. So it's really got to be something ridiculous. It's often got to be like a scrivener's error, something that literally just doesn't make any sense when you apply the plain words of the statute. Just because it's going to lead to an outcome that seems kind of weird, that's not enough to get the rule against absurd results to apply. So now we're going to talk about some substantive canons, not canons like this, canons with one N. Don't do this, by the way. It looks dangerous. All right, substantive canons are judge-created rules that sort of have some sort of policy prescription behind them, or some not codifies, but it holds an important value in the legal system, right? And these are not absolute, kind of like the rule against absurd results. They can be rebuttable presumptions, or they can be tiebreakers when the statutory interpretation analysis is close. And different judges give canons different weight in the analysis and phrase them differently. Theoretically, these encourage better legislative drafting because, again, we presume that the legislature is aware of these canons, and so they're going to draft their statutory text accordingly, which again is maybe giving a little too much credit to what the legislature is thinking about when they're doing statutory drafting, but it's a presumption that we make. So the first big one is the rule of constitutional avoidance, which basically means that you should avoid the interpretation that would render a statute unconstitutional. And again, this is codified in the Code Construction Act, which says in enacting a statute, it is presumed that compliance with the constitutions of this state and the United States is intended.
So if you got two competing interpretations of a word, one interpretation would render it unconstitutional. The rule of constitutional avoidance says, apply the other interpretation of the word. Statutes in derogation of the common law is kind of an interesting one that you really only see at the state level, because obviously there's no real federal common law. And basically, an ambiguous statute is supposed to be construed as being consistent with the common law unless it explicitly goes against the common law rule. This has been a little bit in flux over the last 10, 20 years in this state. That's the general rule, although there's some case law that has kind of walked that back a little bit. This is a quote that's sort of tempering that rule a little bit. So the short answer is, this rule exists in Texas, but if you're trying to apply it in a specific case, look at some of the case law because it gets a little bit confusing. We also have external sources of meaning. Basically, that means legislative history and how administrative agencies interpret the statute. So legislative history, I think you all know probably what legislative history is. It's committee reports. It's floor statements by individual legislators during the deliberation of passing a statute. And I think we all kind of know generally, how like the Justice Scalia's of the world view legislative history, which is, it's not very favorable. It's not big in textualist analysis. What a lot of people don't know is that the Co-Construction Act actually blesses the use of legislative history. So here in 311.023, it says in construing a statute, whether or not the statute is considered ambiguous on its face, a court may consider circumstances under which the statute was enacted and legislative history. So this is interesting because even a lot of intentionalists would say we only look at legislative history when the text of the statute is ambiguous, and then we can use that as sort of a way to glean what the legislature is thinking. The Co-Construction Act actually says, it's on the same level as statutory text, and you can consider it whenever you want. Courts in this state, the Texas Supreme Court specifically, has kind of gotten around this by saying, well, it says a court may consider it, and we're choosing not to consider it. It doesn't say that we have to consider legislative history, and we're choosing not to. Administrative agency deference is something that's fairly new in Texas. Some of y'all know may know about the Chevron doctrine in federal courts, which basically says, if you're trying to interpret an ambiguous statute that an administrative agency has interpreted through either formal rulemaking or through the notice and comment process in a regulation, you're supposed to defer to that agency's interpretation of the statute if the statute is ambiguous, right? So step one of Chevron is the statute clear? If yes, that meaning controls. Oftentimes it's not. So if it's not, is the agency's interpretation reasonable? Oftentimes it is a reasonable interpretation, so the court will defer to the administrative agency's interpretation of the statute. That's sort of classic Chevron deference in federal court. It's been cut back a little bit in recent years, but it's still good law. In Texas, the Texas Supreme Court adopted something similar in 2011 in the case that's here at the bottom of the slide, Railroad Commission of Texas v. Texas Citizens. And what the Supreme Court said in that case was, we will generally uphold an agency's interpretation of a statute it is charged by the legislature with enforcing, so long as the construction is reasonable and does not contradict the plain language of the statute. So the general consensus from the legal community was that the Texas Supreme Court was trying to adopt something that looked like Chevron deference in this case. There's a really important Attorney General opinion down here. I would encourage you to look at if you have more questions about this. It's KP 0115, that was issued in 2016. And basically what that opinion says is, step zero is, was it a formal interpretation? Was it longstanding? Does the agency have the authority to enforce the statute? Does it conflict with the plain language of the statute? And then is it reasonable? So they break it down a little bit more than traditional Chevron deference at the federal level, but it's very similar to Chevron deference. So that's kind of the basics of how to interpret statutes. I want to talk about a Texas Supreme Court case from 2014 now that really, I think, encapsulates a lot of these really interesting issues. And kind of shows you how difficult it can be to apply some of these. So in this case, Jaster versus Comment 2 Construction, a homeowner brought an action against a contractor for damages arising from improper design and construction of the house's foundation. The contractor filed a third-party complaint against the architect and the licensed professional engineer, and the architect filed a cross-claim against the engineer. So basically it looked like this, right? So the homeowner sued Comment, then filed third-party complaints against Austin Design Group and Jaster. Jaster is the professional engineer. Then the Austin Design Group filed a cross-claim against Jaster. So this is the statute that's really on point. We should probably go to the issue first. The issue in this case is when Comment and the Austin Design Group filed their third-party complaint and their cross-claim against Jaster, the engineer, they did not include a certificate of merit. And if y'all don't know what a certificate of merit is, in some cases, like when you sue an engineer for not, doing something correctly in engineering, you have to attach to your petition an affidavit from another engineer that basically says, they did not follow best practices, or they screwed something up that a reasonable, rational engineer should have known not to do. Comment and the Austin Design Group did not attach an affidavit like this to their third-party complaint and their cross-claim, respectively. And so the issue became, were they required to attach a certificate of merit along with their complaints the same way you would if you were filing an original petition as a plaintiff? And so the statute that's at issue here is this statute, and I'll give you all a minute to read it. But this entire text is kind of important, so I'll just give you a moment to read it. All right, so if you've had a chance to read it, you can kind of maybe sense some of the ambiguity in the statute. So it says in any action or arbitration proceeding, you've got to file this. What is an action? That's obviously kind of ambiguous. Does it mean a lawsuit? Does it mean any sort of claim? Like it could be original petition, but it also be like a cross claim or a third party petition. All that's really the crux of this. But all these words, the immediate context in which we find that word, all these words kind of play a role in the analysis. So, what did the engineer obviously said, you got to include this with your cross claim and your third party complaint. These are defective. I should also point out that the statute provides that the case can be dismissed with prejudice if they don't attach this. So Jaster had a lot of interest in getting these claims against him dismissed. So his argument was, for purposes of the statute, there's no real distinction between plaintiff, third-party plaintiff, and a cross-claimant, right? They're all seeking affirmative claims for relief against Jaster, the engineer. These are all actions, right? In their ordinary, their commonly understood sense. So they have to comply with their statute's requirements for any action. And finally, he said, not applying the certificate of merit requirement to third-party plaintiffs and cross-claimants really thwarts the statute's purpose. Obviously, his thinking was the statute is designed to prevent frivolous litigation against, like engineers. You've got to show that your lawsuit has some sort of merit before you just go filing lawsuits and filing claims against people. Now, Comment and Austin Design Group's arguments, obviously, were that they didn't need to include this. They say, the statute uses the word plaintiff rather than the word claimant, which would indicate that just talking about somebody who files like an original petition. The requirement that a defendant who denies the plaintiff's allegations file a certificate of merit will be absurd, unfair, and unreasonable. Because basically the lawsuit has already started. So, what's the point of filing it at that point? We've already started litigation. And even if, it's kind of weird, even if it does violate the supposed purpose of the statute, which is to prevent frivolous litigation, that's not the role of courts to fix. That's the role of legislatures. So normally I would take a vote if we were in person about who wins this case. And I always get interesting results from people. But I will tell you, a plurality of the Supreme Court said that Austin Design Group and Comet were not required to file certificates of merit along with their third-party complaint and their cross-claim, which surprises some people because a lot of people think that the Texas Supreme Court would say, no, we want to cut down on litigation, so you got to file this, but no. 5 justices said you do not need to do that. But obviously you have 3 different opinions here. You have the plurality opinion joined by 4 justices. You have a concurrence by Justice Willett. Then you also have a dissent from Chief Justice Hecht. It's joined by 3 other justices. So the plurality says, plaintiff and action are not defined in the statute, so we're going to get those words. They're common, ordinary meaning, unless the statute clearly indicates a different result. So pretty uncontroversial at that point. They use dictionaries, treatises, commentaries, case law, other definitions from other statutes. How that word is used in the rules of evidence and the rules of procedure, which is a little, as I mentioned before, a little bit ambitious. Normally, courts kind of stick to dictionaries, but they said, no, you can use all these other things too. That's fine. They looked at the relationship between plaintiff and action, common ordinary meaning of the word action. Does that mean a lawsuit? Does it mean like a cause of action? What does suit mean? What does, cause of action is maybe more discrete than like a suit, right? If you're filing a lawsuit, that can contain multiple discrete causes of action or multiple discrete claims. So those mean different things. Bottom line, according to the plurality, is that the plaintiff is the party who initiates the action or the suit, not the party who asserts claims or causes of action within the suit. And so Comet and Austin Design Group are not the plaintiffs in this action because they're not the parties who initiated the lawsuit. And they said this makes sense within the broader context of the statute. So the concurrence from Justice Willett says, is really trying to emphasize context. And he says, it's not enough to just look at the zoom in on what the word action means. We need to really look at the words around it and figure out what the context is of that word in the statute. And so that's part of it. It's all, but part of the context argument was also, the tools that we're using to interpret the ordinary meaning of the word action, like dictionaries, definitions from case law, those are really acontextual tools. You can't just pull definitions from dictionaries and case law and things like that and expect it to have the same, have that word be used the same way that we're using it in this very specific statute. He also kind of criticizes the use of the absurdity doctrine that the parties had raised, which wasn't really adopted by the court. He also says careful textual commitment can encourage careful drafting. When legislatures come to see the courts as editors rather than adjudicators, busy legislators may lead the judiciary to tighten the screws on loose language. So this is a common sort of textualist refrain, which is, by applying, doing a close textual application of in statutory interpretation, we're encouraging the legislature to draft their statutes more carefully and not kind of punt the issue to courts to figure out. And that's something that he sort of ended the concurrence with. So there's a dissent from Chief Justice Hecht. He kind of opens this by saying, the court's opening itself up to criticism that its analysis is picky and detached from reality. We have to apply the words of the statute to make sense, and that's how we respect what the legislature is trying to do. And what he says is, the context is important, but the plurality of the concurrence are actually ignoring a lot of the context in which the statute was enacted. And he thinks that actually indicates that you need to file the certificate of merit with a third-party complaint with a cross-claim. And he kind of takes a shot at this notion that the analysis that the plurality of the concurrence engage in would lead to more careful statutory drafting. And he kind of says, that's not really realistic. Like the legislature is not really constantly watching what we're doing and, paying attention to these cases and these opinions where we're not talking about, hot button issues. The legislature has other things going on, and they're doing a lot of other things. So this legal fiction that they're always paying attention to what we're doing and that they know what how we're interpreting words in their statutes is not really realistic. So that's Jasser. If anyone has any questions, feel free to ask in the chat. But hopefully that kind of gives you an idea, a sense of how the Texas Supreme Court interprets these ambiguous words and phrases, but how it can also be difficult and how it can lead to different opinions. I want to touch briefly on a U.S. Supreme Court case. It's actually a criminal case. The facts of this are pretty simple. So basically, this guy named John Yates, a few years ago, was a commercial fisherman. He caught undersized red grouper in federal waters, which is illegal. So when he was out at sea, there was a kind of inspection point, and the customs guy said, you know what, you're not allowed to have that. That's against the law. Basically, we'll deal with you when you get back to the port. But for now, separate that undersized red grouper from your other fish so we can inspect it when we get back to the port and figure out, how much you broke the law and what we should do with you. So, he lets him go. But then before he gets back to the port, he instructs his crew to throw the undersized red grouper back into the ocean. Basically saying, he was trying to hide the evidence, right? And saying, I don't want them to look at this and see that I've done something bad. They've already tipped me off that they're going to get me in trouble, so throw it overboard. And so instead of just letting this go, the government charges him under two different statutes. The one we're going to talk about, though, is 18 USC section 1519. And that is whoever knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry into any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation or proper administration of any matter, then the jurisdiction of the United States shall be fined, imprisoned not more than 20 years. So he got a long prison sentence for telling his crew to throw this illegal fish overboard, right? And so the government's argument was, well, he destroyed a tangible object. A fish is a tangible object, and he destroyed it, or he concealed it, or he covered it up, however you want to phrase it. He threw it overboard, and so he's guilty under the statute. His argument was, the statute was enacted as part of Sarbanes-Oxley in 2002. For those of you who don't know what Sarbanes-Oxley was, that was passed by Congress in the wake of Enron, had to do with corporate malfeasance, did not have to do with destroying or covering up illegal fish that you catch in the Gulf of Mexico. But he was convicted under the statute. He appealed all the way to the Supreme Court. And the question was, is he guilty under this statute for throwing the fish overboard? And normally, I would take bets about what this is, but the majority opinion said no, he's not guilty of violating the statute because a fish is not a tangible object in this sense, right? That's not what we're talking about here. We're talking about like accounting fraud, right? And like cooking the books. We're not talking about throwing your fish overboard in the Gulf of Mexico. So they go through this whole textual analysis. They look at the context, kind of similar to the last case we read. Justice Kagan wrote a dissent, and she kind of opens it by quoting Dr. Seuss. She says, "A fish is a tangible thing, right?" Like this isn't a hard case, according to her, because she's saying, well, a fish is obviously a tangible object, right? And you destroyed it, or you mutilated it, or you concealed it, however you want to phrase it. But clearly, a fish is a tangible object. I'm just applying the words of the statute. Justice Scalia agreed with this interpretation. Interestingly, Chief Justice Roberts and Justice Alito did not, and they went with the majority. Oftentimes people think that this is kind of like ideological, but a lot of times it's not. I mean, they just had different opinions about what the text of the statute meant. It's a lot of people, look at this case as sort of a textualist versus a literalist interpretation of the statute. That may be a little unfair, but this is kind of a emerging issue, I think, in statutory interpretation, both at the federal level and here in Texas, which is sometimes the text of the statute is clear, but it doesn't necessarily always apply literally in all circumstances. And as part of that, is another example of that. I wanted to briefly touch on a case from the Texas Supreme Court decided last year in 2020 that I think is really interesting. So it's called Exparte EH. That case involved a guy named EH trying to get an expunction of an online solicitation of a minor charge. So if you've ever done any expunctions, you know that basically you file a petition in district court, and then the government destroys all records of that arrest or that charge. The interesting thing about this case was EH had served community supervision for this online solicitation of a minor charge, which normally makes you ineligible to get an expunction, right? Just know the plain text of the statute says you can't get an expunction if you serve community supervision for basically a Class B misdemeanor or higher. Some of you may also know, though, that a few years ago, the Court of Criminal Appeals held the online solicitation of a minor statute, the statute that criminalized it, to be unconstitutional under the First Amendment. So, EH had been got a community supervision for this charge. After he completed the community supervision, the Court of Criminal Appeals says, no, that statute's unconstitutional. EH goes and gets a writ of habeas corpus, says, hey, the statute I was convicted under is unconstitutional. This conviction, this probation, whatever, should not be on my record. So they get the writ of habeas corpus, and then they try to get an expunction. And their argument was, well, I was never really convicted, or I never served community supervision for this charge because, we presume there's sort of this legal fiction of the penal offense never existed, right? Because it was unconstitutional from its outset. And the state argued, well, that's true, but as a matter of historical fact, you did serve community supervision for this offense. And so it's a really interesting case of, do you apply the literal meaning of the statute, or do you sort of bring in this legal fiction that he's never really, he was, convicted, he did serve community supervision for this offense, but in a sense he didn't, because the statute that he was convicted under was later found to be unconstitutional. The Texas Supreme Court said 8-1 that he could get the expunction. We displaced the literal meaning of the statute, and we presume, or not presume, we conceptualize this offense as never having existed because it was later found to be unconstitutional. And there was one dissent from Justice Blacklock who said, no, we apply the literal meaning of the text, we apply the plain meaning, and he's ineligible for an expunction. So that's a good example. I think it's similar. It's a little bit different than the Yates case, but it's similar too, I think, and it's indicative of how this problem can come up sometimes and kind of where the Texas Supreme Court stands on it. And that's really the end of the presentation. If you have any questions, my email is here. If you want to delve more into this topic, I've actually written a law review article that was loosely based on this presentation. You can find the site there, or you can just Google my name and statutory interpretation, and it's available for free online. Or you can email me and ask me for a copy of it. But thank you all so much for being here. If you have any questions, I'm happy to answer that or talk about any of these issues, because I do find this really interesting. But thank you all so much for coming.